Hello, everyone. My name is Clifford Ando. I'm a professor of classics and history at the University of Chicago, and I want to welcome you to a production of the Modern Criminal Law Review. I thank Marcus Dubber, the editor of Modern Criminal Law, for the invitation to assemble this event. Um, uh, my colleagues and I are writing a special issue of Modern Criminal Law on, as it happens, ancient criminal law. And without further ado, I can say more about the kind of project and summation at the end. But without further ado, I'd like to introduce our first speaker, Beth Berkowitz from Columbia University. Beth is co-writing a paper with Mark Asnan. The title of their paper is Final Words as Framing Device, Statements Before Execution in Jewish Antiquity and Today. And with that, I turn things over to Beth.
Thank you. I'm just going to share my screen. Uh, uh, here we go. Um, just trying to put it into the slideshow. Okay, great. So, it's great to be here in this really exciting workshop. I want to thank Professors Ando and Dubber for inviting me to be part of um, this really interesting group. So, in the Supreme Court case Furman versus Georgia in 1972, the justices concluded in a 5-4 decision that the administration of the death penalty in the United States violates the Eighth Amendment's ban on cruel and unusual punishment. Rather than signaling the end of the death penalty, however, states scrambled to rewrite their death penalty laws. And only 4 years later, in Gregg versus Georgia, the Supreme Court reinstated the death penalty. And with the resumption of the executions came also the return of the many rituals that surround it. What literature scholar Paul Klemp has called the execution ritual complex. So, my project, which I'm co writing with photographer Mark Asnan, is interested in that execution ritual complex. Our hypothesis, which is really inspired by this workshop, is that we can gain an insight into execution rituals by juxtaposing the ones in our own day with those of the past. So one of us, me, is a scholar of ancient rabbinic literature, and the other of us, Mark, wrote a book featuring people executed in Texas. And our experiment is to ask what can happen when we put the two contexts into conversation. So our particular interest is the last statement, what Robert Johnson called the existential centerpiece of execution. So here's how the ritual works today in Texas. The prisoner is strapped to the gurney. The witnesses to the execution are brought into the viewing room and they're positioned behind a plastic barrier. It may include loved ones, the victim's family, press, other official witnesses. A microphone, which you can see in this picture, is placed in front of the prisoner. And the prisoner, he or she, usually he, speaks to the assembled. And the verbatim full text of the statement is transcribed by staff who listen from a remote location through a PA system, and immediately after the last statement is made, the execution commences. And the Texas Department of Criminal Justice later posts the statement on its website, which you can see here. So, of the 27 states that authorize the death penalty, all have some sort of protocol for last statements. Some set time limits, some don't have the microphone, some allow last statements only in writing. Officials are allowed to cut people off if the last statement gets too long or if it's considered inappropriate. James Jeffers when he was executed in Arizona in 1995. He started cursing and making obscene gestures. And after that, Arizona began to screen and to edit last statements. So the last statement also plays a critical role in the ancient execution ritual that's found in the Mishnah and Tosefta, which are legal collections composed by the early rabbis who lived in Roman Palestine in the second century CE. So there, what happens is the court delivers a guilty verdict. The convicted person is taken out to be executed. Person is it's a little complicated. Person is stationed on the steps of the court in case last minute evidence emerges. And then the condemned person begins the procession to the execution site. There's a herald that precedes him that announces the execution to the public. The herald issues a final call for exonerating evidence. And then when the condemned person approaches the execution site, that's when they direct him, it's usually him, to make up, but it actually also includes women, to make the last statement, which the rabbis claim here assures for the executed a portion in the world to come. The rabbis treat the possibility, you'll see, that a person will not know how to make a confession. And they also treat the possibility that a person will claim to be innocent for the crime for which they're being executed. And the rabbis actually prohibit the person from making such a claim. And after the last statement, there is this interim step. The condemned person is stripped, and that's when the execution then is performed. So the last statement is an enduring element of the execution process, as criminologist Mona Lynch has observed. There's an acute mortality salience, which is what sociologists call it, to this moment before execution, when imminent death is certain. The last statement is thus uniquely positioned to capture this existential drama of human life, but it's also uniquely positioned to capture a certain moral drama of guilt, repentance, forgiveness. You could say it's the ultimate confession, when the confessor has nothing more to gain or to lose. So if Foucault is right, that humans are the confessing animal, then you could say final confessions capture the very essence of being human. But last statements are not always confessions, even though that's the way the Mishnah presents it. The condemned in today's the condemned in today's executions, they do often confess their sins and beg for forgiveness, but they do a lot of other things too. They express love and gratitude for family and friends. They encourage their fellow inmates. They criticize the institution of capital punishment. They accuse the authorities of bias or error, or they just start cursing, as Jeffers did. So, in sum, the last statement affords the executed an extraordinary degree of agency in a ritual whose main aim is to deprive them of it. So that's really the paradox that drew me to the ritual of the last statement. Now, the scholarship on last statements, which I've been diving into, is really abundant, but it does tend to stick to one context. And by co-writing this piece, we're hoping to build upon the existing scholarship, but also maybe shed the limitations of a single context in order, hopefully, to gain new perspectives on this fascinating, disturbing, often heartbreaking legal ritual. And we also hope to decenter the Christian perspective that tends to dominate. So, with that in mind, we've structured this project by first doing a deep dive into the ancient Jewish texts, and we work our way through the ritual statement as the rabbis conceived it. And then we turn to contemporary last statements in Texas. And our method is to juxtapose the various elements of the rabbinic procedure with a single last statement that we've selected from the state of Texas that we think somehow speaks to the rabbinic ritual. So we're still in the midst of the work, but I'll just give you a snapshot. So, and feel free if I start to go over time, just, cut me off, I guess, in the spirit of execution. So, I want to focus on this scenario in the Mishnah of this condemned person who doesn't know how to confess. And I want to pose an extremely basic question. What does it mean for someone not to know how to confess? So here it is, yeah. So in a classic Mishnah commentary, one rabbi speculates that the condemned man does not remember the rest of his sins, but other possibilities may be that a mere 15 feet from the execution site, the person may be so frightened or emotionally overwhelmed that they're unable to put their thoughts together. It's also possible the Mishnah is speaking of a condemned person who does not wish to make a statement. Perhaps they're filled with remorse or a sense of futility. Perhaps they decline to make a statement as a way of objecting to the court's decision to execute them. So these readings of the Mishnah I've found feel quite relevant to today's executions. Up to a quarter of those executed today decline to make a last statement. The psychological burden of the moment is intense, and it actually surprises me that anyone is able to give it a last statement while strapped to a gurney about to be executed. And compounding the problem is the number of people on death row with intellectual disabilities, mental illness, and a low level of education, where even under normal conditions, these are people who might not have an easy time formulating a speech. So I had the Mishnah scenarios in mind of this, person who doesn't know how to confess. When I was looking across the modern last statements on Texas's website, and I came across the one of Douglas Roberts, who was executed on April 20th, 2005. And I'll read his last statement. Yes, sir, Warden, okay. I've been hanging around this popsicle stand way too long. Before I leave, I want to tell you all, when I die, bury me deep, lay two speakers at my feet, put some headphones on my head, and rock and roll me when I'm dead. I'll see you in heaven someday. That's all, Warden. So let me tell you a little about Roberts. He says in his words that he was stoned out of his mind on crack cocaine when he abducted someone and ordered them to get out of their car. The person lunged at them, he stabbed them to death, ran over the body with his car, and then actually drove to another city and turned himself in. Now, Roberts' last statement is really unsettling in its jocularity. He describes his experience on death row, or maybe it's life itself, as hanging around the popsicle stand way too long. He has to be buried with headphones and speakers and to be rock and rolled when he's dead. So there is no rehearsal of sin here or seeking atonement, though he does actually speak of the afterlife, but it's a pretty kind of rocking afterlife that he's imagining. According to news accounts, he was upbeat and animated during his final statement. He smiled and mouthed, I love you all, to friends and witnesses, and said, I've got to go, as the lethal injection was administered. And his affect and words really struck many people in the press as inappropriate. So I think it's interesting to imagine Douglas Roberts as the kind of man the Mishnah describes as someone who doesn't know how to confess. And so our question is really, how might Roberts's last statement shed light on the Mishnah? And in turn, how might the Mishnah offer essential background for these practices today and understanding some of the details? So I'll leave you here. Oops. Let me just get to the slide with just, I don't know. Yeah, just some of the questions that we're exploring in this project. How can today's execution rituals help us fill in the blanks for the past and vice versa? So thanks so much for listening. I look forward to our conversation.
Thank you, Beth. That was really wonderful. Next is Ari Bryan of Vanderbilt University. Ari's paper is entitled "The Emperor's Dark Shadow: Confiscation and Criminal Law in the Roman Empire." Ari.
Thanks, Cliff. I don't have any nice slides, but I'll try to say something controversial nonetheless. Um, my goal today is to suggest that we've been thinking about criminal law in the Roman Empire in a way that's fundamentally wrong, or at least seriously inadequate or partial. When we tend to think about criminal law, we have in mind, or at least I have in the forefront of my mind, the image of the subject or even the citizen before the judge, and before a judge who normally bears the conventional marks of sovereignty. A man who, in the Roman world, would normally be an emperor, praetorian prefect, or a provincial governor. This person, invested with what we would call in Latin jurisdictio, would first pronounce upon guilt and innocence, and if he found guilt, would then normally administer punishment. Now, this image is not incorrect, but I think it's highly partial. To begin with, in the Roman world, there were only but so many people with jurisdictio at any given time. And in an empire of some 50 million inhabitants, these acts of jurisdictio must by necessity have been rare. Even with large staffs helping to assist these various sovereigns in terms of things like fact-finding and the punishment of minor offenses, we're still talking about a system that must have been hugely overwhelmed, even in comparison to a very overwhelmed modern penal system. So many things must have sat on the books for a long time, not been prosecuted at all, or been dealt with summarily. But more importantly, when we imagine this sort of sovereign jurisdictio, we imagine a system where the state's gaze and then eventually probably its force is turned against a certain kind of person. And this is where I think the view is somewhat misleading. There was certainly attention to persons in Roman criminal law. But if we look to where the thickest bureaucratic elaboration sat, we would have to admit that the system is concerned most not with persons, but with property. So in my remarks today, I'd like to take a page from the work of our host, Marcus Dubber, and suggest that there were actually two systems of criminal law in operation in the Roman Empire. One concerned primarily with the punishment of persons, and the other concerned primarily with the punishment of property. They did cross over, of course, and in many places, but they ultimately obeyed different logics and were staffed by different personnel and governed by many different sorts of procedure. As such, we might reasonably speak of a dual penalty system in the Roman world, but it's not the one we normally think of. That is, it's not the one that distinguishes between honestiores and humiliores, or high and low class people. Again, to echo Dubber, it's one that distinguishes, on the one hand, between personal liberty and integrity, that is, the ability to do and to be without pain or disfiguration, and on the other, a system that deals with the liberty of the householder to own and administer, with all the attendant privileges that come with the position of patriarch, including, most importantly, the right to bequeath property to one's children. Now, in the minutes that I have, I can only begin to sketch this as a basic matter, and of course we can come back to it in discussion. But I want to start with a sense of scale. Fergus Miller has done the basic groundwork on the question of what the Romans called bona damnatorum, goods confiscated from those who had violated the law. Here, of course, we're talking about a moment where these two systems intersect, but it's still valuable to understand it, right? These are moments where someone had violated what is normally a statutory provision, and as a consequence, been sentenced to a punishment that revoked his membership or her membership in the community, right? Death, exile, condemnation to the mines, this kind of thing. Miller did this exercise in order to better understand the wealth of the emperor who took over such properties as his own, right? That is, he wanted to understand the nature and extent of the fiscus, or the cash and properties administered by emperors. And though Miller was careful to eschew quantitative conclusions, even those on a basically comparative scale, he was nonetheless staggered by how quickly the wealth of emperors grew and grew vast as a result in part of taking over the properties of the condemned. But, and I think this is the important part, there was extensive confiscation besides that which emerged as part of sentencing for specific statutory crimes. Most prominent are laws that sought to use the fiscus to enforce boundaries between statuses. So in Egypt, the various laws concerning status boundaries compiled in the gnomon of the idios logos were enforced by confiscation normally at death. So falsely declaring one's Egyptian child an ephebe, that is a Greek, was punished by a confiscation of a fourth of one's property. Requests to freedmen not yet freed were confiscated fully, and so forth. And similar penalties existed outside of Egypt. So confiscation is the standard punishment for making a tacit fideikommissum, an arrangement whereby a trust was designed as a workaround to avoid the requirements that Romans only take from other Romans in their wills. Avoiding the census, right, refusing to subject one's person, family, and property to scrutiny, similarly resulted in confiscation. The list of reasons for confiscation might in fact be rather extensive and subject to any number of judgment calls. So the jurist Callistratus offers as additional examples someone taking under a will or codicil, which he was not entitled to benefit from, property passing to an unworthy or indigenous heir, property that had been suspected of being given to the emperor in an earlier will, which had been purloined or destroyed. You confiscate when someone buys property from the fiscus at a windfall price. You confiscate when the object of controversy in a lawsuit has been sold off, when treasure has been discovered on imperial properties, when an accusation has been abandoned, and so on and so forth, not including all the reasons for which are prescribed by statute for which you also confiscate. Confiscation was similarly aimed at those running cities, right? So failure to perform one's liturgical duties, that is one's mandatory public services, ends, you guessed it, with the confiscation of one's property, thus ending any chance one's heirs had for holding a similar place in the social and political hierarchy. Now, so far as the evidence allows, it seems that only land and property were confiscated. Asterisk, I need to actually check this a little bit more closely. And you might imagine a world where if you kept assets in cash, you'd be better off. But with that said, right, any sort of failure to perform these kinds of duties would have evolved eventually needing to leave one's entire place of residence, would involve needing to up sticks and try again somewhere else. Now, in some cases, this would have been a risk worth taking, but in others, it would have meant ruin for one's heirs and constituted a major source of social and demographic churn. This species of confiscation, that is, this species of punishment, is not the application of the violence of some pure sovereignty, but the quieter and no less painful work of an administrative bureaucracy. And the bureaucracy that was in charge of this system of confiscation, the fiscus, was extensive indeed. To begin with, imperial properties were administered not by sovereigns with jurisdictio, but by a network of procurators, freed people, and slaves in the direct control of the emperor himself. While governors could theoretically intervene in this system, they were discouraged from so doing, even when it was quite apparent that those in charge of this system operated it to their own illegal enrichment. The fiscus also operated internally according to its own structure of rules. It had a specialized bar where young lawyers would cut their teeth early in their careers, and it was designed also to withstand external challenges. So if one wanted to protest its abuses, it didn't make it easy. The fiscus only provided its own records to certain people, namely those with rights to them, and then only on the condition that they not be used in any case against the fiscus, right? So those requesting documents would be required to provide surety that they would not so use them on penalty of losing one's case. And even if they did need such documentation to challenge the fiscus, they would only be given 2 months to make any challenges to confiscations. Now, I could go on, and I'd love to, but Cliff only gave me 10 minutes. So I'll instead wrap up by making a series of suggestions about the logic of this practice. First, whereas the penalties meted out on the person were fundamentally individual, confiscation is generational. It keeps children from inheriting, and in this regard, it seemed harsh even to Romans, who at times endeavored to return property, or even bits of property, to heirs. But this was never the default rule. And in targeting property, it necessarily also put heirs at a major disadvantage for social mobility or even for preserving their station in life. Second, We might do a bit of thinking on the ways that ownership was conceived in such a system, right? In this world, it is not a natural pre-political fact, but something deeply contingent on the authority of the Roman state and the promise of political and financial obedience. I would suggest that it would be worth digging further into this because on such an account, property ownership presupposes a hugely intimate and invasive entanglement with the state and with the emperor, albeit at one remove. Um, Still, this must have been a major way that individual subjects interacted with their state, with their sovereign, and with his agents, and I think it deserves more thinking. Finally, I want to suggest that at least at the level of cultural logic, confiscation might be considered alongside two other practices to which it is analogous, even if these analogies are imperfect and even if I haven't fleshed them out entirely. First, and I'll just be brief here, is taxation. That taxation and confiscation sit in an interesting relationship to one another. Taxation is often explained in some cases, or some cases explained as the penalty for what generations before had done in terms of rebellion and so forth. We need to think about that more thoroughly. But second, there's a link between confiscation and civil execution, right? The ways that civil judgments might be satisfied by a victorious plaintiff, um, which happened essentially by allowing the judgment creditor entrance onto the whole property of the debtor and causing the debtor to be classified as infamous or civilly disadvantaged. Here, I'll simply make reference to a standard handbook, Wenger's Institutes of the Roman Law of Civil Procedure, where Wenger writes, quote, Roman law deems execution to be the bending of the will of a stubborn debtor. It partakes of the character of criminal law. The system of confiscation supervised by the fiscal bureaucracy was similarly designed to bend wills, and we might imagine that this was a process every bit as heart-wrenching as being dispossessed from one's home today, still one that happened to happen more slowly and less spectacularly than the confrontation with the sovereign that jurisdictio represented. Okay, I'll stop there and I welcome your questions.
Excellent. Thank you very much. Our third paper today is by Sai Liang of the University of Notre Dame. The title of her paper is Paranoia and State Power, The Perils of Performance Legitimacy in Early China. Liang, please.
Thank you, Cliff. Is the PowerPoint clear? Let me put into the presentation mode. Okay. First, let me say my sincere thanks for Cliff to invite me into this community. And it's a great opportunity for me to exchange ideas with scholars beyond my immediate fields. So I, Chinese historian, concentrate on intellectual and legal history of early Chinese empires. So this paper, or right now this talk, is based actually on my recently published book, Convict Politics, From Utopian to Serfdom in Early China. I talk about briefly about the Qin Han empires, correspond to Rome Empire, last from the 2nd century BCE to 1 CE, almost 200 years. So after I finished the book, I found a paradox, which interesting but not yet answered by my book. So let me start with this kind of intellectual history of ideas. So Chinese, early China have a legalist school of thought, if we could follow that term, legalist. So they represented by Han Feizi and Lord Shang. So let me summarize their argument. So they advocate very harsh punishments. So they said, I punish people not because I want to torture people, because I regard those people as tools to give lessons to the rest of the population. They said the harsh punishments actually would scare people and make them dare not to violate any regulations or any legal statutes. In an ideal situation, harsh punishment, even for minor transgressions, would get rid of punishment, then we will achieve a utopian, crime-free society. But this legalist idea is well elaborated, found kind of logic, but at the same time, you got the Confucian scholars, which think exactly the positive. They said if you punish people with out of the proportion of their crimes, you punish harshly about minor mistakes or errors, actually you will punish the honest people. People work so hard to their jobs. And you will discourage the most diligent, devoted person and make the mediocre one don't know what to do or paralyzed. Or, I might make a mistake. Facing harsh punishment, I might just give up. I don't do anything. But they also mentioned that actually the harsh punishment, according to ideal standard, will make the petty man not only survive the system, but actually they will occupy the most important positions in the bureaucracy and thrive. How could that happen? So that is exactly I want to argue. I could not. Okay, I don't know why I could not move the PowerPoint. Okay. So, I try to, integrate intellectual history with the political history and legal history. We're extremely lucky in early Chinese legalist history. So in the recent 30 years, or especially in the recent decade, we have extremely rich legal cases and legal statutes excavated from tombs and from deposit pits. So the number is almost 1 million. We have complete legal statutes and in different categories excavated. We have complete dossier of legal cases excavated. So that's really give us advantage to revise or give new light of the legal history of China, early China, which has long been ignored for decades. So in this, my book is based on a lot of excavated legal statutes. So in my book, actually, I found I argue it's this kind of brutal perfectionism. So you have an idealized standard, and you prescribe them as a legal statutes and impose them on the performance of the officials. So because you have a high standard, almost perfection-oriented standard, no one could meet that standard. So you would extensively criminalize the people. So I will show you what do I mean extensive. But also another characteristic of the early Chinese law is they criminalize the administrative errors. I use criminalize not because they are punished, but they are criminalized as people who robbed their neighbors, who killed their slaves, or killed their friends. So they exactly criminalize administrative errors there. Let me give one examples. So the Grand Master of Ceremony, one of the 9 ministers in the central government in the Han Dynasty. So they exercise tremendous power. I could document every Grand Masters of Ceremonies of 200 years history of Western Han Dynasty. So but the number is very interesting about, or sometimes astonishing about their, criminal record. So 27 out of 41, over 60% were accused violate the legal statutes. Majority of those accusations is related to job performance. It's not they really receive bribery. It's not they do not do well. So I give you examples. Sometimes it's their subordinates not do well. Because the sacrificial animals were underweight according to the legal statutes. So the Grand Master of Ceremony at the moment was punished as war builders, that you send it to the garrison and build the Great Wall with people who killed their neighbors. And also sacrificial wine becomes sour. The minister are going to be prosecuted. If you mishandle the foreign envoy or their letters, you were punished by war builder. That's recorded cases in our source. And if you recommend someone as a disciple of the erudite of Confucius classics, it turns out the one you recommended is underperformed, right? It's not show the quality you recommended. So you as the people who recommended was sentenced as war builders. That's I talk about the brutal perfectionism, any mistakes. Think about their students we recommended for graduate school, we recommended for their jobs. They might underperform. But in the Han Dynasty, if that happened, you are going to become a criminal. Okay, so I talk about that and give you another example about the absolute liability and punish the minor mistakes. It's from excavated legal statues from tombs written on the bamboo strips. They say they have detailed legalization how you submit your administrative reports. They said when you submit your administrative reports, they regularly submit their performance reports. So if you intentionally deceive your superior, intentionally do it, you will become a wall builder, or may become green pounders, hard labor, free labor for the government. But how about you accidentally make a mistake? For example, make a typo. You will be fined about 4 liang of gold. So calculated that means, that about 62 grams of gold, pure gold. And it equals about 210 days of work if you make one typo in your administrative report. Also, you constantly make that administrative report monthly, annually. That's your job, paperwork. So it's not the law was extremely sophisticated. They differentiated different penalties according different levels of consequence, or differentiated different intentions, but they call for absolute liabilities, not tolerate any mistakes. Okay, so under that kind of high performance oriented legal system, we got these numbers, right? Throughout 200 years of Western Han Dynasty correspond to Rome Empire. So I could document all their chancellors. You could say around more than 40 of those chancellors, they were accused violated the law. And almost third of them died. Some of them, 6 of them, under Emperor Wu's half-century rule, died when they're serving as died, face death penalty, or died in the prison, meet their death while they're serving as the head of the bureaucracy. Similar trend, right? So you got 36 of the chancellors were accused violating the law, and 5 of them meet of their deaths. Some of them died in the prison. Most of the accusation is related to job performance. Okay, so let me summarize. Is throughout the Western Han 200 years history, you got 40% of those high officials face prosecution or convicted. They will really work as hard labor or die in prison for in their cases. Okay, so then I got a paradox there, right? So the legalists then thought high performance mandated by the law actually will promote high efficiency. I think to that extent it's right. We are facing an empire existed 2,000 years ago. Rural population about 60 million occupy a territory of 2/3 of modern American territories. So they could run the empire relatively successful for 200 years. So that might be right. The high performance oriented law promote proficiency and ask for accountability. But at the same time, you got people says, so, you know, when you have that system, even those who most diligent people who work so hard for their job, they accidentally made one mistake, they will be get rid of their game, though, right? You will punish those who were earnestly committed to their duties. But also, you know, that's I go back to that. But also, you know, they would say, you know, high performance, no, the Confucians complained. Even you could promote efficiency, but you will push people to lie to you because they're scared about the harsh punishment if they accidentally made their mistake, or they don't have that capacity to perform the job performance as prescribed by the law. They will not only lie to the superior, they will collectively lie, everybody lie to, you know, in order to, you know, make to survive. But, you know, that's, you know, I got a lot of sources talk about, you know, how people who lie could not only survive, but thrive in the system. Then I got very, very confused. Is that exactly this paper I want to solve? How can liars survive? Not only survive, but also thrive. So you feel it's this kind of paradox, right? You got so strict legal regulations, harsh punishments, and those punishments are implemented. You got 40% of the high officials become prosecuted and, you know, convicted. So it's the legal system actually was implemented quite thoroughly. And also you got archaeological excavated text. See how the local officials were prosecuted for minor mistakes, for underperformance. You got abundant of those cases. But why, at the same time, you got persistent deception and collective concealment? People who lied still could survive and thrive. And also, only people lied from our sources. The contemporary says only people lied could survive. So, you know, that's, you know, we could approach this kind of paradox from the state power and the infrastructure, right? So because we could say how the law was implemented, but from both the transmitted sources, which was compiled 2,000 years ago, compiled at the contemporary time, and to the archaeological excavated legal source, which preserves the direct information of Han Dynasty without later scholars' editing efforts, all show us actually the state has quite astonishing power to implement the law. Right? If you honest people did not do well, could be punished, how could a liar survive? So I got, you know, very, very confused. So, you know, in the paper, I want to raise several important questions. Why did the official choose to lie despite the risk of severe punishment? How did the deception become rational strategy? And how people would choose to collectively lie? Okay, but the most important one, how those people who lied to their superior could survive and prosper despite extensive legal enforcement. So, you know, that's, you know, instead of, you know, I want to talk about state power, but I also think about probably right now we have to turn to the probabilities. Is honest people work hard, have more chance to survive in this system, or people who are liars? So I'm inspired by, you know, the Robert Axelrod's book, Evolution of Cooperation. He used prisoner's dilemma to use computer simulations, right, to see how people would respond. So, you know, I take advantage of early China, you know, legal statutes because we have very detailed legal statutes survived even, you know, in this 2,000 years, right, in the deposit pit or in the tombs. So I try to use a computer to simulate the historical events and from the probability to explain how liars in a strict legal empire could survive not only survive, they could occupy important positions and exercise power. I will give one case. For example, you got so many detailed legal statutes, right? You got different scenarios. So you could design the computer, to run different scenarios, and through, hundreds times, you could say what's the probability, who would survive, who would die, who would get out of the game or become the prisoners. Okay, I will stop here.
Thank you. I should confess that I've read a considerable part of the manuscript of this book much earlier on, and it's a totally fascinating corpus of material. Next, Benjamin Gallant, who's at NYU Shanghai, and his paper is entitled "The Things Between Us: Criminal Law and the Construction of Property in Early China." Welcome, Benjamin.
Thank you so much. And I want to thank Professor Ando and Professor Dubber for this opportunity to join you. And I'm honored to have the chance to present my research alongside far more distinguished colleagues and to be part of this special issue of Modern Criminal Law Review and its kind of larger project of offering new perspectives on criminal law, in part in kind of regard to the nature of police power and political economy. And I'm actually joining you from East Asia, where it is a bit after midnight, so I apologize for any lapses in lucidity that may result. And so discussions of criminal law in Anglophone contexts almost necessarily presuppose the existence of a separate civil law that deals with the bundle of rights that define property. Now, there's been a lot of research that on kind of the idea of civil law in China, and showing that there are aspects of the law that are comparable to civil law. And one leading scholar, writing of a later period, said that Qing dynasty law embodied the practical reality of civil law and property rights without their representational realities. And so there are parts of early codes that deal with things like inheritance that we would think of as civil or administrative, but I'm interested in a slightly different set of questions here. And the first is what it might mean to think about movable property through the lens of criminal law, and particularly the law of theft and the sanctions for theft. And the second is, why does the law of theft become so central to early Chinese law? And the answer I present in this paper is that it is particularly aimed at defining and protecting government property, though it also does the same for private property, and that it emerges alongside a new kind of corporate conception of the state, particularly in the 3rd century BCE. And so to kind of begin with a theorization of political economy and criminal law that we see in early texts, in particular, a text from the 3rd century BCE called the Book of Lord Shang that I think Professor Cai has really aptly summed up with this notion of brutal perfectionism. And this is a text that may be of the most interest to people working on kind of modern criminal law. And so in a chapter on the origins of law, the text argues that historical necessity demands the creation of officials in government offices, and then ultimately a ruler, to oversee the allocation and division of people, things, and land, and to create prohibitions to maintain and protect those allocations. Now, in regard to actual legal practice, it's a little bit different. We can see that it's more accurate to say that the prohibitions are kind of shaping the nature of the allocations. Thus, rather than a kind of private law oriented toward the interaction between isolated individuals, there's already a broader conception of the necessity of penal law from the perspective of the political economy of the state, in an attempt to steer people towards certain patterns of enlightened self-interest that are, in theory, supposed to serve the needs of the greater good, or at least the state. And in what was appropriately named the Warring States period, this meant agriculture and war. And with official offices as a reward for military service. And so there's a fundamental ambivalence about private property within the text, as the wealthy were seen as a potential threat to the state, even as the penal order aimed to ensure that people remained committed to the production of agricultural commodities that the state could tax. Now, according to Qin and Han law, the punishment for theft was generally various forms of penal servitude or a fine, with the government as a beneficiary. And stolen goods were generally returned to the victim, but only in instances in which the government is the victim is there anything significant in the way of compensation in the form of penal servitude or a fine. And so, as I noted above, the development of this legal framework happens alongside the emergence of a new kind of conception of the state, capable of owning things, and to which one could have various obligations, including fines and debts. So while I think the law of theft was initially primarily directed at defining the bundle of rights associated with state property, it also became a framework that was applied to private property. And in addition, one of the central ways of dealing with quantifiable damages was to apply the laws of theft. And at the risk of simplification, this could be done either by asserting that an act constituted theft or by asserting that it was comparable to theft. And so there is this incessant mechanism within the legal imaginary to return to the question of whether or not an act is theft. Now, we can get a glimpse of the sometimes overlooked importance of state resources from a very famous moment in the context of the Civil War in the late 3rd century BCE, from which Liu Bang emerges victorious and establishes the Han Dynasty. So he arrives at Xianyang, the capital of the preceding Qin dynasty, and temporarily replaces the Qin legal codes with a simplified set of prohibitions against killing, wounding, and theft. And so this has traditionally been understood as a way of kind of gaining the support of the people. And within Marxist influenced kind of 20th century historiography, it has also been read as a moment in which he kind of aligns with the landlord class. And while the law of theft did, in fact, in some sense, protect private property, it doesn't address the question of state property, or this view doesn't address the question of state property, or perhaps it would be more accurate to say that a Marxist framework in which the state is seen as a representative of a particular class is adopted that erases the tensions between the interests of the state and economic elites. And so recent archaeological discoveries have allowed us to explore the extent to which the early Qin state was active in the economy. And if we carefully examine the narratives about the rise of Liu Bang, we can see that much of the focus is actually on the way in which he's securing state property with the expectation that it would ultimately pass into his hands, although it ends up being more complicated than that. Now, there's a recurring quote in early Chinese texts that those who steal belt hooks are punished, those who steal states become feudal lords. And so Liu Bang and the other rebels are actually referred to with the same term that is used for thieves. And perhaps because of kind of this possessive state that emerges and the difficulties involved in conceptualizing rebellion, this same term that is used for thieves is also used to refer to bandits, rebels, other enemies of the state who are excluded from the political community, even as their own attempt to monopolize violence and seize resources closely paralleled the actions of the state. And so the term for kind of the state allocation of resources was also the term used for kind of the distribution of stolen goods. But returning to the second question I mentioned, I want to offer several examples to explain what I mean by thinking about property through the lens of theft. In the Institutes of Gaius and Justinian, dating to the 2nd and 6th century CE, there's a famous and much discussed passage about the capture of wild animals as an example of the origins of private property. Now, within the 7th century Tang Code, which was based on earlier codes, there isn't a directly equivalent passage that attempts to explicate the origins of ownership, but one does find a comparable and rather elaborate account of the point at which taking something becomes theft. And so, for instance, to have stolen a bird, you need to have kind of obtained absolute control over it so that it can't fly away. And so there are other examples in that later code, but going back much earlier in the Qin to the 3rd century BCE, there's an extremely intriguing law that states that for a father to steal from a son is not theft. This doesn't apply to foster fathers, though. So here again, the father appears to have a sort of privilege to help himself to his son's movable property. And this dual relationship is defined not in terms of a positive statement of the father's privilege, but through the denial that this constitutes theft. So it's kind of a negative statement instead of kind of a positive statement of what he can do. And so we can think about the creation of various kinds of rights in the sense that property interests are being recognized through the law of theft, such that the criminal law is playing a role in kind of working out the representational realities of the bundle of rights associated with state and private property. And so I think it's also likely that the separation of ownership and control inherent in state property managed by officials may have also facilitated the development of collective rather than absolutist conceptions of private ownership. But I'm still trying to work my way through kind of the ideas that I'm trying to develop here. So thank you all again, and I welcome your comments and suggestions.
Thank you very much. We're going to pause now after the first 4 of 8 papers for some brief discussion. I don't know if anybody wishes to raise a hand. Perhaps I could start by simply posing a question to Liang. I guess I'm interested in the suggestion that the Chinese state of this period was high performing. And I suppose I'll pose a question which will lead to one question which will lead to a second. And that is to say, what would a low performance version of the Chinese state look like? And how would we know it was low performing? And the reason I pose that question is there are times in the way you talk where one wonders uh, uh, about something like in this concept of so-called lying, right? That is it possible that something like the discourse of state performance is essentially an internally rationalized discourse of the bureaucracy, in which it makes demands for performance or demands for things that count like state knowledge, and other people in the bureaucracy return answers to them in the form that look like, accurate state knowledge. You call that some of those answers you could suppose are sincere and some of them lying, but I wonder whether instead of imagining as you seem to do that the state is sincere and sometimes other people, officials, are lying back to the state, whether there isn't, I mean, I don't want to call it a mirage, but whether one shouldn't imagine the kind of discourse of officials as essentially an internally rationalized system that has no particular, its epistemology is not a correspondence one. That is to say, the discourse of the state isn't supposed to or isn't intended to correspond to some accurate mapping of material realities. And therefore, we don't know, and in fact, they didn't know whether the state was high performing or not.
Thank you. I think you just, challenged me the idea, what is conception, right? So I think also what is performance? So I see this high performance is from modern standard, talk about their scale, how prosperous the empire in terms of, their population, their material goods. So we think, compare, counterpart or even use modern standard, it's quite high performance empire. Also, it lasts about 200 years. But for the contemporaries, none of those officials think about they are doing well. So Chinese have a utopian complex. We are compiling a book, talk about that. So if you read the sources, everybody is criticized how bad the empire is performed. Because the ideal situation about high performance is the whole universe, the whole cosmos would in harmony. No disaster would ever happen. Without without implementing law, no crimes would ever appear. So you say, who is talking about the performance from what perspective? But I understand when you ask a question, you challenge me what conception means, right? So the conception means is they would lie or code against their reality. For example, from excavated text, we know their record annual report. So they said they have a population of about thousands villagers. They said they have more than 10 people or more than 10 people achieve longevity of lattice. So it's a standard even modern day could not acquire. And also it's not I say they lie. No, I don't say they lie. It's the sources from the emperor to the officials. They constantly complain people who lie could survive. So, okay, I will stop here.
Okay, sure. Anyone else? Adrian, please.
Thanks. So I had a question for Beth. I find the project really fascinating. And I guess one one important feature I think to consider when looking at these things in different contexts is the question of audience and who is actually supposed to be the audience of these last statements. And so I was curious a little bit about that, especially in the Jewish context, but the long history of sort of the transition from public to private execution. And so these sort of like allocation statements, so much of it is about who the audience is in some way. And obviously like a ton's been done on the Massachusetts Bay Colony and so forth. So I wondered how you saw that fitting in.
Yeah, one of the most curious things about the rabbinic procedure is how little attention they give to the matter of audience. Is you can kind of infer who must be there, but they're not interested particularly in how this will play to an audience and the impact of the audience. I've been reading about final statements today and the sociological analysis, which I've been surprised to find is like extremely computational. Like there's a lot of very quantitative um, type studies on like the themes of last statements. And one of the tracks within the research is what is the impact on the last statement and its themes of it, is the victim's family there? Is the clergy there? Like how does who's there? It seemed to correlate with the kinds of themes that come up in the last statement. And it stands to reason that the members of the audience would make a difference to what the person says. And that's sort of one of the things I'm hoping to be able to do is what's frustrating about the ancient material are the gaps. And I mean, that's why there's a expansive exegetical tradition, is to try to fill in those gaps. And one of the big gaps actually is, and when I wrote on this material a long time ago, I wrote quite a bit about this question of audience and kind of what do they seem to be assuming about audience, but why don't they make a bigger deal about audience? In the few stories in early rabbinic literature where they have rabbis being executed by the Romans, there is a sense of audience. So when the rabbis execute them, when the rabbis represent themselves as executioners, why don't they represent audience? So I'm curious in thinking about audience today and looking at the scholarship on audience, if it could somehow help me fill in how that would have played out for rabbinic execution. But I think the bottom line is what's most curious about the rabbinic procedure is that they don't seem to care very much about audience, which is very strange. And I think that's one of the things that's helpful in terms of making the comparison is to see what's so strange about the ancient procedure. Thanks.
That the lack of concern was, I'll take your word on the lack of concern for audience is curious in light of the their representation of the movement of persons through space, through from private space into a public space and so on. And they're clearly moving through some sort of urban setting, and it's monumentalized in particular ways. And yet, human beings in that space go relatively are under mentioned, you might say. Anything else? If not, why don't we have time obviously for more discussion later on. Why don't we move to the next paper, paper number 5, which is by Adrienne Lonnie of Harvard University. The title of her paper is Criminal Justice Without an Independent Prosecutor, Context and Culpability in Classical Athenian Jury Trials. Adrienne.
Thank you. And thank you to Professor Ando and Duber for inviting me to participate. This is a really interesting group of people. So I'm very happy to be here. So imagine a criminal system where statutes are broad enough that a prosecutor can credibly charge nearly anyone with a crime. Imagine further that criminal prosecutions can be motivated by political enmity. In 2026, you might assume that I'm talking about the US Department of Justice. And I'll return to that comparison in my concluding remarks, but I'm actually talking about classical Athens. Athens offers an example of a criminal system designed to handle prosecutions brought with suspect motives, a problem that modern criminal law scholars are now urgently studying. The Athenian response involved empowering trial juries to decide not just whether the elements of the charged offense had been met, but whether the defendant in his behavior posed a serious enough threat to the community to merit criminal prosecution and punishment. In other words, the Athenian jury exercised the kind of discretion typically reserved to prosecutors in the American system. In fact, the specific charged incident, or actus reus in modern terms, often played a relatively minor role in Athenian court speeches. Athenian juries routinely considered a variety of factors beyond whether the elements of the charge had been proven. To borrow the terms used in the DOJ manual advising federal prosecutors on when to bring a case, Athenian jurors considered first, the nature and seriousness of the offense, second, the defendant's history with respect to criminal activity, third, the defendant's personal circumstances and the probable sentence or other consequences if the person were to be convicted, fourth, the deterrent effect of the prosecution, and fifth, law enforcement priorities. So I'll explore how Athenian juries considered each of these factors in criminal trials. Now, in the interest of time, I won't discuss the evidence that Athenian private prosecutors were often explicitly motivated by personal and political enmity. This isn't a controversial point. So on to the Athenian jury's enforcement of something akin to the factors listed in the modern principles of federal prosecution. The treatment of violence offers an example of how Athenian juries considered context beyond the actus reus to evaluate the nature and seriousness of the offense. Surviving court speeches suggest that proving the elements of the battery or intentional wounding statutes was not sufficient for conviction. Rather, the jury needed to be satisfied that the incident, considered in its whole context, was sufficiently serious for a criminal prosecution. In the two defense speeches involving violence that survive, both defendants admit hitting their opponent, but suggest that the incident doesn't merit criminal punishment. For example, in Lysias against Simon, an intentional wounding case arising out of the fight over a lover, the defendant argues that severe penalties are inappropriate for cases like his, in which, quote, people are wounded while fighting because of drunkenness or quarreling or games or insults or over a courtesan, the sorts of things that everybody regrets when they recover their senses. For their part, prosecutors in violence cases typically anticipate that their opponent will similarly argue that the fight was a trivial matter that should never have been prosecuted in court. For example, Ariston, who was jumped at night in the Agora by a group of men returning from a drinking party, predicts that the defendant Conon will try to, quote, reduce the attack to laughter and ridicule. And the prosecutor in Isocrates against Lochides feels the need to justify his decision to prosecute a battery, even though the blow did not result in serious injury. The implication of all these arguments is that the Athenian jury will assess not only whether the statute was violated, but whether criminal punishment was justified under the circumstances. Second, the Athenian jury also routinely considered what the DOJ manual refers to as the defendant's history with respect to criminal activities. Athenian prosecutors commonly place the specific charged incident in the context of a broader pattern of criminal behavior by the defendant. In modern American law, of course, this evidence would be considered highly prejudicial and inadmissible at trial. But the defendant's criminal history is routinely considered by prosecutors in deciding whether to commence or decline a prosecution. In violence cases, the Athenian prosecutors often detail how the charged assault was just one example of the defendant's tendency to act with violence and impunity. Ariston presents the late-night attack in the Agora as typical of Conon and his son's habitual drunken and abusive behavior. He recounts how Conon used to run with a rowdy crowd as a young man, a tradition continued by Conon's sons who called themselves itaphaloi, literally those with erect penises, a term that likely refers to obscene cult practices. He also describes Conon's sons as perpetually drunk and out of control during their army service. He repeatedly committed hubris against the enslaved persons Ariston brought to camp by beating and urinating on them. In this way, the jury is encouraged to consider whether punishment is warranted based on facts that go well beyond the specific incident of the assault in the agora, or what we would think of as an actus reus. An even clearer example is provided by Demosthenes' prosecution of Midias for punching him in the theater. In his prosecution speech, Demosthenes mentions only obliquely the punch that set off the prosecution. Instead, he reads out a list of crimes Midias has allegedly committed against other people, asserting that he would have considered the incident a private matter if only Midias had not committed many acts of hubris, impiety, and other serious crimes against others. In this way, Demosthenes depicts Midias as deserving punishment not only because of the punch at the festival, but also, and in fact primarily, because the assault was part of a pattern of criminal behavior that posed a danger to the community. Third, defendants often ask jurors to consider their personal circumstances and the effect the proposed punishment will have on their families. There are many examples of this, and I will mention just one here. The defendant Andocides notes that he is the only surviving member of an old and noble house that has included many public benefactors, and asks the jurors to consider that if the prosecution succeeds in securing the death penalty, his entire family line will perish. Fourth, the Athenian jury was also encouraged to consider the sort of policy questions reserved in the modern system for prosecutorial charging discretion, such as the deterrence value of the case and current law enforcement priorities. Athenian prosecutors regularly argue that a conviction or severe sentence is necessary to deter future offenders. To cite just one example, in a capital case against grain dealers, and the charge is a little bit unclear, it's either hoarding or price fixing. But anyway, in this case, the volunteer prosecutor argues that the deterrent effect of a conviction is particularly important in commercial cases like these, and here I'm quoting. It's obvious to everyone that trials about such matters are of general interest to those in the city. If you condemn the defendants to death, the other grain dealers will be better behaved. If, however, you release them unpunished, you will have granted them immunity to do whatever they please. It is essential to punish them, gentlemen of the jury, not simply because what has happened, but also to set an example for the future. In this way, the prosecutor calls on the jury not simply to evaluate the facts, but to make a policy judgment about the deterrence value of conviction. Now, my final point, that Athenian juries sometimes considered the importance of enforcing the offense given the circumstances of the time, what we might think of as law enforcement priorities, is much more speculative. The law against impiety may offer an example. Now, there's no surviving prosecution speech from an impiety trial, and our evidence for impiety cases is notoriously difficult to interpret. But it seems clear that impiety was unevenly enforced at best. Certainly, Socrates was engaging in whatever behavior you think got him indicted long before his prosecution, and we know that several famous philosophers questioned the existence of the gods without attracting charges of impiety. It seems likely that there was a sense among both potential prosecutors and jurors that acts of impiety should be punished only if they rose to the level of threatening the moral, social, or political order. The tendency of impiety indictments, not just against Socrates, but others as well, to include the allegation that impiety involved corrupting the youth, may reflect this view. In other words, in some cases, Athenian jurors might consider whether enforcement of the offense was a priority at that moment. Now, regardless of whether one views Socrates' trial as primarily religious or political in nature, it seems clear that in 399 BCE, the Athenians viewed Socrates as a serious danger to the community and thought his prosecution was in the public interest. Now, there's a ton more I could say about this, but in the interest of time, I'm just going to have to leave it at that. So, in short, precisely because the Athenians had no independent gatekeeper to ensure that a given prosecution was justified, Athenian litigants presented not just the facts tending to prove that the crime was committed, but all the relevant circumstances showing that the defendant did or did not deserve punishment in a much broader sense. So to return to the modern comparison, what can the Athenian system tell us about how to rein in politically and maliciously motivated prosecutions by the Trump DOJ? Now, jury nullification is an obvious answer, and both trial juries, and particularly grand juries, have had some high-profile successes in this regard, most famously in the case of the protester who threw a sandwich at a federal agent. The grand jury and the trial jury offer a particularly potent form of resistance to government overreach because, unlike judges, law firms, corporations, and universities, it's difficult for the president or other executive branch officials to retaliate against or even criticize popular bodies like the grand jury or the trial jury. In very high-profile cases like the sandwich thrower, the grand jury knew enough about the context and the politicization of these prosecutions to exercise independent judgment. But this is not typically the case. We've seen that a central feature of the Athenian jury's ability to check unjustified prosecutions was its access to information about the broader context of the offense, the defendant's circumstances, and the likely penalty, as well as policy considerations supporting or opposing punishment. None of this contextual information is typically provided to the modern grand jury or trial jury. We limit them to the specific facts of the case, the sort of actus reus. And that's partly because our system is predicated on the assumption that an independent and fair-minded prosecutor will consider all these factors before a case is ever brought to the attention of a jury. Given the brave new world that we now find ourselves in, if we're to entrust our freedom to popular juries, we need to trust them more, just as the ancient Athenians did. Thank you.
That was excellent. Super clear and on time. The next paper is by Mark Letney. Mark exists in a kind of liminal space between two different jobs. Mark is in the process of departing the University of Washington for Princeton University. His paper is entitled "The Birth of the Jail: Prisoner Taxonomies of the Roman Empire." Please, Mark.
Thanks so much, Cliff, for inviting me to this very exciting venture, and especially in the 2 weeks when I'm formally unemployed. Thanks for pointing that out. I'm going to share my screen. In 539 CE, the Bishop of Gerasa dedicated a new building. Paul had served as bishop for over a decade in modern-day Jerash, Jordan, and his tenure involved an intensive program of building and beautifying within the city, including a number of new church buildings, a new pool and theater, and towards the end of his life, the bishop personally dedicated a jail. We know this because of a dedicatory inscription, which reads, here you could see it, Paul, our most blessed bishop, by the grace of God, raised up this holy building of the detention center because he approved it as beneficial. And in the name of the Lord, he blessed this detention center, that is, to be for all the accused apart from the condemned, so that no person found guilty could be put there with impunity, nor anyone could be transferred from the detention center to the prison of the condemned. And he hands over the person who transgresses his holy sanctions to the judgment of the Lord. The structure that Paul dedicated does not survive, much to my regret. I wish that it did, because analyzing the facility in the context of other securely identified late antique prisons might help us to see what architectural distinction made a difference between a prison, that is, a facility designed to control convicts, and a jail, like this one, meant for the confinement of the accused. There's much more to say about this inscription, though lamentably little has been said about it. What has been published asks primarily after the status of its proprietor in the 6th century. For instance, in Julia Hillner's analysis showing that this inscription demonstrates that, quote, by the mid-6th century, as confirmed in Justinian's legislation, bishops were fully fledged judges, end quote. The initial editor of this inscription is right to note that, quote, it is an important document for legal history, for the history of the relationship between episcopal power and the city, and for religious history, end quote. He is right, because this is the very first instance of a jail in the historical record. That is, it is the oldest attestation of a purpose-built facility intended to hold accused people while awaiting trial, separate from those who had been condemned. A few others have noted this inscription, but it remains largely unintegrated among the broader field of late ancient history. The lack of scholarly attention is surprising because on its face, it appears to overturn the classic Foucauldian historical model in which the jail has existed since time immemorial, while the prison is a uniquely modern invention. But the Bishop Paul's dedication seems to suggest that the classic model is precisely backwards. Along with Matthew Larson, I've written elsewhere on this point, and I won't dwell on it here. But today I begin with this text because it articulates an aspect of Roman carceral policy that deserves more sustained analysis, which I intend to give in my contribution to this forum. My article asks a rather simple question of literary, documentary, and epigraphic evidence. What distinctions obtain within carceral spaces, and how are they expressed spatially? I build on important work by Hillner, who rightly doubts that any one-to-one relationship exists between, quote, imperial attempts at ordering prison space, end quote, and the material arrangement of prisons in practice. But the status quo ante has shifted in recent years. We simply know more about prison spaces themselves now, and new data opens room to ask more detailed questions about the taxonomy of prisoners, the typology of spaces, and the relationship between the two. Paul's dedication is one example of, in fact, a long tradition in which ideological architecture classified prisoners of different types and sorted them into spaces commensurate with those classifications. In Western Eurasia, this intellectual tradition stretches back at least to the 20th century BCE with the Sumerian hymn to the goddess Nungal, a text that envisions a single facility holding defendants until their trial, after which they are either cleansed and released or damned and returned to the prison. The most famous articulation of carceral classification and its spatial consequences appears in Plato, who envisions an ideal society with three different types of carceral space. First, a large public facility for keeping what he calls general offenders in custody. A second facility called the reformatory, the sophrosunisterion, near the meeting place of the nocturnal council. And a third facility outside of the city with a name that signals what it is meant to induce, that is, punishment. That is to say, each of these sources speaks to a discourse in which operative lines of difference are constructed and deployed. Differences between people of different types, and occasionally between spaces of different sorts. The goal of my article is to identify those operative lines of distinction and to understand as best I can how categories shift over time. Paul's spatial distinction between those awaiting trial and those already convicted seems to be a genuine innovation of the 6th century CE, and perhaps it was unique to the Levant or even unique within it. Likewise, we should not assume that classifications of prisoners were consistent over time or space, or even that practices mapped onto ideals in any predictable manner. Still, understanding the varieties of classification and how they map onto carceral facilities may allow us to see aspects of ideology encoded in archaeologically attested spaces of carceral control. So in what remains of my time, I want to offer just a few vignettes that classify prisoners and deploy that classification to sort prisoners in space. I'll end with some potential conclusions and some implications. So, as Ari mentioned, in broad strokes, among idealized carceral policies from the Roman imperial period, the most relevant distinction between offenders of different, the most relevant distinction was between offenders of different classes. Except in special instances and in cases of abuse, only lower status individuals were notionally subject to bodily carceral control. Though I will note, as an aside, that abuses of the prison are in fact uses of the prison, and that they are historical data at least as relevant to this conversation as is lawyerly hand-wringing. Beyond class distinctions, at least in legal sources, we often see distinctions made between people awaiting trial and those who have already been convicted. There are many examples of this, but one of the clearest is a law of Constantine in 320 CE, in which the emperor instructs the fiscal controller, Florentius, that trials ought to be as speedy as is practicable, but that in cases when the prosecutor is away or discovery is necessary, that custody in what the law calls loose chains is acceptable. Further, during the day, defendants ought to be led out to the open areas towards the front of civic prisons so that they can enjoy the salubrious effects of light and clean air. In the idealized world of Constantine's law, quote, the idea is that the prisoner not perish from the punishments of prison, which is regarded as pitiable for the innocent, but not sufficiently severe for the guilty, end quote. So here we have one line of distinction between those awaiting trial and perhaps those who remain in the prison after conviction. I will say nothing here about whether a potential punishment would simply be further incarceration. I will simply note that the architecture of many carceral spaces from the imperial period seem to allow for an operation like the one described in this law. That is, they include separate spaces with different material conditions, and these spaces may reflect precisely this kind of idealized practice. Another operative line of distinction reflects the sex of prisoners. We see this, for instance, in a law from one of Constantine's sons, who proposes that separate prisons should house male and female prisoners apart, or perhaps separate sections within the same facility. In this law, interestingly, it is yet more ambiguous as to whether people envisioned inside are under custodial or penal control, especially given that it identifies the space of the prison itself as part of their punishment. There's lots more to say, but I want to end with one further distinction that may be relevant to this audience in particular, which is the use of punitive isolation within Roman prisons. That is, the use of solitary confinement, which appears for the first time in the 2nd century CE Life of Tiberius by Suetonius, describing the horrors of the Second Emperor's carceral policy, which included shutting some prisoners up in small facilities where they, quote, were denied not only the consolation of reading, but even the privilege of conversing and talking together, end quote. Cicero and the grammarian Varius Flaccus likewise speak to late Republican and early imperial practices of torture through solitary confinement. So that's the project. My aim here is not to explain why Romans placed people into carceral facilities or even to detail the conditions within those spaces. Rather, I'm hoping to understand the various and constantly changing intellectual architecture which categorized prisoners once they arrived inside. What does this allow us to do? Well, recent years have involved an uptick in the archaeological identification of Roman carceral spaces. For instance, Martin Mosa just this year identified what is potentially the military prison of Vindobona in Austria. And George Kupcha proposed recently an identification of the civic prison of Sarmezagatuza in Romania. These spaces uniformly are multi-roomed facilities. My hope is that a better understanding of the ideals around prisoner location can inform a reading of the ideology encoded in Roman prisons that are appearing more and more in the archaeological record. And I hope a more regionally and temporally granular understanding of carceral ideals can help us refine our typology yet further. A typology that I should say I had a hand in creating, but one that is currently based only on a preliminary survey, not a full accounting of either the literary and documentary, nor indeed the archaeological record. There's a lot more work to be done, and this study represents one part of that necessary labor. To conclude, there's no one-to-one relationship between the way that prisoners are categorized in texts and the way that they're treated in space and in time. There is, nevertheless, some relationship, and the first step towards understanding more about the experience of carceral control in the imperial period is trying to understand the history of taxonomic thinking about prisoners of different types and the sorts of facilities into which they were sorted. Thank you.
Thank you very much, Mark. The next paper is by Seth Richardson of the University of Chicago. His title is To Catch a Babylonian Thief and a Tooth and a Clown. It so happens that Seth is not able to be with us, and I'm going to read his paper because, among other things, Seth is treating substantively a period that is not otherwise represented in this conversation. And also, I had the kind of intuition, which I think will turn out to be correct, that the kind of method that Seth is employing related in part to the kind of evidence he has at his disposal, is also the kind of method Seth is pursuing is also relatively his own in relation to the other papers in the group, and I thought it would be useful to have it fully represented as part of the conversation, both for the audience for the seminar and for the participants to the project. So, my paper, I'll read Seth's paper. My paper steps off from 2 points of evidence, both leading back to the person of the Babylonian thief. The first lets on to a problem of taxonomy, the second to a question about semantics. To describe the first problem, in a 2016 paper, the Iranian scholar Hossein Badamchi took the Akkadian verb most commonly and conventionally translated to steal, sharaku, item 1 on the handout. I apologize now for my pronunciation of Akkadian. I did race this morning and try to find YouTube videos of native speakers of Akkadian whom I could imitate, but my search was unsuccessful. And I didn't have the wisdom to ask Seth how to handle this. He took the Akkadian verb sharaku out onto the workshop floor and took it apart piece by piece. He had an intuition that a modern sense of theft was an inadequate translation for the verb by its focus on the unlawful taking of someone else's property. And so he gathered attestations to show that the many contexts in which the verb appears ought to lead us to often translate something other than simple theft, but adjacent concepts, including nearer senses of fraud, embezzlement, and receipt of stolen goods, but also others further afield, such as perjury, breach of trust, and abduction. In our thinking, these latter crimes belong to classes of legal offenses different from theft, impairing administration of justice, fiduciary responsibility, and personal freedom, respectively, so their assimilation here to theft is suggestive of some different principle. Badamchi's intervention thus substantiated earlier doubts about the fixed sense of sharaku and isolated its discrepant meanings. In these discrepancies, we had an opportunity to disguise as a problem, partly because Badamchi left some next step questions untouched, including the distinction of sharaku from a half-dozen semantically adjacent verbs, which also mean to rob, appropriate unlawfully, which are used contemporaneously in the Middle Bronze Age texts he studied. Some of these words were very common. Seth refers to section 2 of his handout. And there are some Sumerian equivalents as well. Badamchi did little more than to bracket such words as, quote, more particular concepts, and implicitly subsets of sharaku, but there is surely more to say. It is therefore critical to investigate the context of all these verbs, their lexical productivity, etymological bases, and idiomatic extensions. Sharaku, as an example for the rest, already forms 2 adjectives and 4 nouns for thieves and stolen things, both concrete and abstract, one of which was in generous adverbial use. And here I'll cite section 3 of the handout. The later Standard Babylonian dialect added 2 more nouns and 3 more adverbs. Such productivity is not unusual for Akkadian verbs, but it's a good litmus test for semantic permeation into other concepts by way of idiom and analogy. So it's not only that a verb meaning to steal was used to make a word for thief, but that we find so many unaccepted subjects who might act or be like a thief. Theft becomes a concept assimilable to reign, social capital, productive fields, prostitutes, to secret lovers, signatories to a treaty, lazy ox drovers, blood from a wound, the smell of bitumen. There is also generic reach. Sharaku terms are found in letters and law, omens and curses, poems and hymns. Much of this proceeds from the verb's unsurprising semantic basis in qualities of stealthiness, sneakiness, and roaming movement, whereas other verbs for stealing bear less subtle tones. Habalu connotes oppression, mashao suggests force, snatching for habatu, loss for halaku. In the strictly legal context studied by Badamchi, what really stands out is the sharaku thief's core quality, not so much of embodied, but of ethical stealthiness, of deceit, not only in the misrepresentation of the ownership, number, and quality of a thing he falsely sells or keeps, but of his falseness as a merchant, shepherd, or witness. This is a subtle distinction to be substantiated later, but I believe I can show that this deceit goes beyond specific acts of lying and graduates to the inversion, perversion, or impersonation of social roles. The thief is not a thief because he stole something. He is a thief because he is a liar. And he is a liar not because he is a liar because he is not a merchant, shepherd, or witness. The swindler is a not businessman. The rustler is a not shepherd. The perjurer a not witness. The infractions the law punishments are not so much acts of theft or even of lying, but of fraudulent identity. Babylonian theft requires crypsis, camouflage used to hunt or hide. From a strictly legal standpoint, this clarification already has significance because the label of thief for non-stealing crimes has been Exhibit A for understanding Mesopotamian legal reasoning as analogistic. That is, the idea that other criminals are metaphorically like a thief is, one, not what is written. The law simply says that a perjurer or a buyer of stolen goods is a thief. And two, thus possibly not analogies at all, but specific ideas about offenses against personal identity. Thus, although semantically capacious, the charge of thief was quite literal. A different sense of thief is given by the Sumerian term equivalent to Akkadian shiraku, but which may in the end lead right back to the sense of identity theft, imitation, even parody. This is the Sumerian term ludzuhu, which can be read literally as tooth man, see item 4. I propose to understand the thief in Sumerian as a biter, a nibbler, a gobbler. This is speculative, but thief as nibbler is supported by literary contexts and is consistent with many Mesopotamian expressions for economic consumption as forms of eating. I believe this explanation for the term has not been made before, but I mention it mostly as a bridge to an even more speculative correlation of ludzu, tooth, to alonzu, the Sumerian term for clown. Item 5 on the handout. The literal reading of which would otherwise be utterly opaque image of a tooth. Alonzu is loaned into Akkadian as aludzinu, jester or parodist, in turn a likely etymon for Greek aladzon, making it one of the few Sumerian words descending into Greek. Now the term alon is a famously slippery word with a wide range of meanings related to imagery, from concrete statue or picture, to figurative form or stature, to even more abstract likeness or appearance. The word carries the potential of verisimilitude, but also of simulation. Thus, I propose that alonzu, image of a tooth, is a double play on ludzu, thus image of a tooth man, furthering the sense of false identity we see in shiraku. The clown is a kind of faux thief. It is necessary in support of this risky equation to emphasize that both identities were grounded in acts of imitation. The performance of the Mesopotamian shiraku and aludzinu, just like the Greek aladzon, were rooted in simulations of professions. The Babylonian clown is a performer of some kind, but not just a juggler or a goofy guy setting his farts on fire. He is someone who inverts professional knowledge to illogical ends to skewer the disciplines. He claims to be an exorcist, but he gets rid of the ghost by burning your house down. He claims to be a shepherd, but he pastures his sheep on mice, because the word for mice is a pun on pasture and also a euphemism for a sexual organ. And there, among the claims of the aludzinu is, I can't stand a thief, but whatever I see doesn't stay where it is. So he's a parody of a thief, who is already a parody of a businessman, who ends up stealing everything anyway. This all capitalizes on the subtext of shiraku as fraudulence and extends further into a sense of impersonation, simulation, false identity, building on that notion of theft as a perversion of profession and roles. I come to two hypotheses. Item 6. The first is that Mesopotamian law punished fraud, and especially impersonation, more than it did theft of property. Property theft was epiphenomenal of identity theft. that the law treated theft as a consequence of ethical harm rather as the misappropriation of property, as superficial readings have it, points us to a discrete subtext. The claims to purpose made by Mesopotamian laws were implicitly moral more than they were regulatory of property regimes. The second conjecture is that exuberant analogies in Mesopotamian literature took theft as a productive metaphor for the parody of all kinds of accepted social roles by inverting them. Theft grounded a principle of criticism, not in the criticism of theft or thieves, who are depicted as anything from lovers in the night to social bandits to indeed dastardly criminals, but a criticism of claims to role and status, of professions, and even bodies of professional knowledge for their capacity to deceive. So, let me stop sharing. Okay, and then the last paper for the day is by Andrew Wolpert of the University of Florida, and his title is The Prosecution of Public Wrongdoing in Classical Athens. Andy.
Thank you very much. I'd also like to begin by thanking Professors Ando and Dubber for organizing a special issue on modern criminal law about ancient criminal law and inviting me to participate. I've already seen from our panelists today how productive such a dialogue is, so I'm really looking forward to the special issue when it comes out. I'm here in Florida, and for some reason, the grounds crew just started mowing right outside my office. So hopefully it's not too loud where you are. All right, so it has been often noted that modern distinctions between punishment and revenge cannot be mapped neatly onto the legal discourse of classical Athens. Athenian law operated in fundamentally different ways from modern legal systems because it was embedded within and served to promote a participatory democracy. Yet despite the differences, McCormick's theory that modern law is an institutional normative order can be applied usefully to the prosecution of public wrongdoing in classical Athens, given the dynamic nature of the Athenian legal system. The Athenian courts were relatively autonomous and fairly stable, but they were also subject to change through their internal workings and from external pressures and forces. The trial was an arena not only for the contestation of legal rules, but also for their articulation of commonly shared beliefs. As Athenian litigants presented their cases, they often expressed ideas about law, justice, punishment, and revenge, so that their statements would conform to the norms and values of their fellow citizens who judged their cases. However, they did not simply voice what they thought the jury wanted to hear. The exigencies of the case and the political and social context of the dispute influenced how litigants appealed to their fellow citizens. And because Athenian norms and values were fairly elastic and sometimes contradictory, litigants could and did draw upon them in competing ways. In the process, they sometimes changed how their fellow citizens perceive these norms and values. An institutional approach helps us better understand how these various elements played out in Athenian courtrooms. For my paper, I will use Lysias 12 against Eratosthenes, Demosthenes 21 against Midias, and Apollodorus' speech against Neaira as 3 case studies to examine how prosecutors of classical Athens portrayed the offense allegedly committed by the defendant, their reasons for bringing the legal action, and the emotional response the offense should elicit in the members of the jury. They sought to cast the defendant as a dangerous threat to the Athenian people who must be punished to restore order, preserve the democracy, and protect the safety of the community. Although there were a variety of legal actions that public officials could lodge, Athenian law not only permitted, but as Professor Lonnie mentioned, depended on private Athenian citizens to volunteer to prosecute individuals guilty of public offenses. However, public prosecutors were generally not neutral parties. They were usually the victims if the offense was directed against an individual, and either the personal or political opponents of the defendant if the offense was directed against the city or its institutions. As they presented their cases, they regularly collapsed the distance between the jury and themselves. Punishment imposed on the defendant was rendered a form of revenge for the prosecutors, the jury, and the Athenian people. Thus, for structural and rhetorical reasons, the kinds of distinctions about punishment and revenge that appear in theories about modern criminal law did not exist in Athenian legal discourse. When seeking to persuade the jury to convict the defendant, public prosecutors often called attention to both the retributive and utilitarian functions of Athenian law. For the remainder of my time, I will focus on their descriptions of its retributive function because Athenian ideas about revenge and retribution stands out most. Didonai dikein, to give justice, and lambanein dikein, to take or receive justice, are commonly used phrases in ancient Greek to describe the punishment of wrongdoers. Because the literal translation of these phrases are awkward in English, they are often translated as to pay the penalty and to exact punishment. Unfortunately, the reciprocal exchange, give and take, that is emphasized in the ancient Greek is lost in these idiomatic translations. For the Athenians, an act of wrongdoing created an imbalance that required a remedy. Because the perpetrator caused this imbalance, he was required to surrender something to the victim, and the victim was permitted to take something from the perpetrator. Dike, justice, and timoria, punishment, are equivalent to the harm that the victim has suffered, and they represent what must be taken from the perpetrator to restore order. As Kucharski has shown, public prosecutors regularly refer to the jurors and themselves, and only rarely the city, its laws, and the lawgivers as the agents of Dike and timoria. Justice was not meted out impersonally because the Athenians never fully distinguished punishment from revenge. Because the Athenian people were viewed as ruling Athens, they, not the government of Athens, were the agents of justice. It was not the city, but the Athenian people actively engaged in the legal process who meted out justice. These notions about justice, punishment, retribution, and revenge also explain why public prosecutors often depicted themselves as enemies of the defendant and sought to elicit the jury's anger. There is some disagreement among classicists about the extent to which public prosecutors acknowledged enmity, since the corpus of Attic orators also contains speeches in which they either denied or did not mention their hatred for the defendant. The context of the dispute, the prosecutor's relationship with the defendant, the charges lodged against the defendant, and the ways that the prosecutor sought to present himself determined whether he expressed, denied, or avoided mentioning his hatred for the defendant. Enmity clearly could not be the sole reason for a prosecutor to lodge charges against his opponent. However, if the defendant committed a wrong that had harmed the prosecutor, that was a different story. The Athenians expected an individual to hate a person who had unjustly wronged them. For public suits, enmity could even alleviate the concern that the prosecutor was engaging in malicious litigation. Still, the prosecutor had to convince the jurors that his enmity was justified and served their interests. Otherwise, he was vulnerable to accusations that enmity motivated him to trump up charges against the defendant so that he could settle the score in a private vendetta. Thus, enmity needed to be situated within legal claims about the harm to the prosecutor and harm to the community for it to be justified. For Aristotle, hatred differs from anger because one can hate a person who has not harmed them, whereas one can only be angry at somebody if that individual has caused them harm. This explains why, as Rubinstein has shown, appeals to the jury's anger appear most frequently in the speeches of public prosecutors. Since the outcome of most private suits did not normally impact the jury, it was often inappropriate for private prosecutors to evoke the jury's anger. Public suits, by contrast, concern the community. By evoking the jurors' anger, public prosecutors sought to convince them that the defendant had committed an offense that warranted a public suit and deserved their anger because his actions had harmed them or their interests. Moreover, emotional appeals, as Aristotle recognizes, have a cognitive component. Prosecutors evoke the jury's anger to support legal arguments about their own actions, the conduct of their opponents, and the merits of the case. So litigants sometimes responded by accusing the opposing party of misusing emotional appeals to distract the jury from the weaknesses of their legal arguments. Hatred and anger were appropriate emotions for parties of the dispute to feel, express, and evoke, as long as these emotions were in response to legal wrongs committed against them or the community. Although we can observe patterns and frequency in the evocation of the emotions, statistical studies can only take us so far for three reasons. First, there are only about 100 court speeches that have survived, and many of them are quite exceptional, including the three that I will be studying. Second, litigants often seek to elicit particular emotions in their audience without explicitly evoking them. Tracking the frequency that anger words, for example, are used in a speech can be misleading if one doesn't also examine the implicit ways the speaker elicits anger. This is why scholars now generally prefer the Scripps approach for the study of the emotions. That is a holistic analysis of the context, scenario, and narratives in which particular emotions are elicited over a labels approach. That is a lexical analysis of specific words. Third, the facts of the case determine whether and how litigants evoked particular emotions. For these reasons, I will be applying a case study approach to show how the structure of the Athenian legal system and the dynamics of the dispute impacted the rhetorical strategies that public prosecutors employed to persuade the jury to convict the defendant. For Athens, law and rhetoric were inextricably intertwined. Thank you.
Thank you very, very much. So we are almost magnificently on time. Thank you to all participants for being so disciplined. I'd like to open things up to a conversation about the second papers in particular, but also anyone who wants to ask a broader question, or for that matter, to return to the first four papers is welcome to do so. I wonder if I might start by asking a question of Adrian. That is, I'm interested that there's some one kind of knowledge that is, as it were, possessed by certain players in a modern courtroom that is not that you did not discuss, and that I take it an Athenian jury didn't necessarily have, and I actually kind of think wasn't much discussed in Athenian speeches, and that was the pattern of the prior application of specific statutes to cases. And I wonder if, I mean, I have my own thoughts about what it means that this is not a form of knowledge that they much discussed or deployed, and I wondered to turn that over to you.
Yeah, I mean, so it's very difficult to have precedents for a lot, in a formal way for a lot of reasons. One is that the jurors, you have 500 jurors and they don't write an opinion. So there's no reason, and probably each juror might have had a different reason for why they may have held a certain convicted or acquitted in a particular case. So the ability to sort of do the kind of precedential reasoning that we do today, where you're going to elicit a ratio dicendi of the previous opinion and then apply it to the case. So as a formal matter, it's very difficult to do that.
But the litigants don't raise this either, do they? Do they?
What's that? The litigants do. So one of the things
Okay.
that's interesting is that litigants in court speeches use a kind of informal precedent
Right.
where they call on other speeches and say, and they always talk about the Athenian jury as though they're the same jurors. It's one body over time. So you convicted Socrates, even though, of course, this current jury is not the same composition as the jury that convicted Socrates. And so they do talk about previous cases and make comparisons, although, their analysis of why the previous case came out the way it did, is up for debate. The
Right.
other thing I'll say about it that's interesting is there's a key feature of precedent in the modern law, which is, as a matter of ethical responsibility, you are required, if you write a brief, if there is a case directly on point that goes against you, you are required to cite it. Now, not surprisingly, no Athenian litigant ever says, oh, there's this bad case, but let me try to distinguish it or say that it's different. Of course, they're only focusing on cases that clearly are in their corner. And for that reason, the sort of complexity of the kind of even the informal precedential argument that you get is quite different from what you would find in a modern case. But I should say, I mean, Professor Wolpert, probably knows as much or more about this than I do. So feel free to jump in on this as well if you have a comment.
The only thing I would add is, so with Demosthenes 21, there's that case where he says the guy almost got off of murder because he was struck so violently and it was so humiliating that some people thought he didn't deserve to be convicted of murder. But I don't know if the precedent it fits in with the argument that Demosthenes wants to make about how bad the hubris was that Midas committed against him. So it seems like he's making up the precedent, and it's completely fabricated. I think that's supporting what you're saying, really.
Mark?
So while we're on the sort of the topic of these Athenian court speeches, I wanted to ask both of our relevant speakers to say something about the intended audience of these speeches, not the initial audience of the oral versions, but the intended audience of the sort of written, published, or otherwise circulated versions. And I, of course, this is a question that you will need to deal with in the paper, but I wanted you to sort of speak a little bit about how you see these speeches as either reflecting practices or, in fact, prescribing practices that are not part of the Athenian democratic process already.
Did you want to know about the published version? Is that where you were, the audience of the published version, or the composition of the jury?
Why? No, the audience of the published version. Why publish these things in the first place? And are they actually reflecting practices on the ground, or are they attempting to, by publicizing certain ideals, create practices that are in fact not part of the process in the first place?
I mean, that's I'll continue this. I'm very torn because I recently published an article about Lysias 1 where I'm not sure it was actually delivered in court because the claims he makes that he has to go through in order to prove his defense seem kind of outrageous to me. Because at any rate, so the more I look at each individual speech, the more I'm like, they might be published, and this is all just based on looking at the corpus, that they're fascinating rhetorical and legal arguments, and they're pulling out ones that are exceptional. So the more I look at the individual cases, the more I look at them as being exceptional. So it's problematic from that point of view. But again, this is sort of some assumptions I'm going with. On the other hand, I do think that they are following the practices that you'd have to make in order to, that they're representative of the kinds of proofs and arguments that you'd have to make for an Athenian jury. But they're calling attention to cases that have very interesting dynamics. So they're exceptional cases. That's where I would leave it. So it's both normative, it's normative in some ways and exceptional at the same time.
Yeah, I would only add, I agree with that. And there are several potential problems. I mean, one is elite bias. So by definition, the cases that, or the speeches that survive are those that were attributed to a canon of 10 oratic orators, the best, right? And so to what extent does this reflect what ordinary litigants said? And then the second problem is, I think, the one you were mentioning, which is, a logographer or speechwriter presents a speech to a litigant, that litigant, without notes, it's not like they're writing it, they're speaking extemporaneously and pretending to be spontaneous. What is the relationship between the speech written and the speech delivered in court? And then what's the relationship between either of those things to the speech that's finally published to get clients in the future, which is probably a more elite audience? And the best example of this that people argue about is Aeschines against Timarchus, famous case about, male prostitution. And some people have noted a kind of tension in the arguments that are made and the attitudes toward male practices, male same-sex practices. And there is a suggestion that there's a kind of addition at the end to appeal that is a more positive view of sort of elite same-sex practices to sort of appeal to the elite readership, as opposed to when you're talking to a jury, which is more like there's a lot of question about who is on the jury, but probably more likely to be less elite than the reading public. So there are all sorts of problems there that I think are impossible to untangle with any certainty. It's a great question.
Okay. Beth? Oh, you're still muted.
Do we have time for more
Sure.
questions?
Yes, please.
Great.
We can go a few more minutes. Absolutely.
Okay. So I have kind of an out there question for Mark. I'm wondering if you've thought about parallels between carceral spaces for people and carceral spaces for animals, since there are some of the same needs when you're imprisoning people and imprisoning animals, where you have holding pens, you have the need for fresh air and outdoor access. You need to keep the children apart from the adults and the males apart from the females. And I know there's some work on mechanisms of restraint that were kind of inspired from use with animals for use with people. So I was just curious if you'd kind of gone down that road or thought about that.
It's not as out there a question as you might surmise, because it is in fact built into the structure of the Latin sort of taxonomy, or the sort of the Latin descriptions of places where animals are held in the first place. So, for instance, in an amphitheater, there will be a carcere, a prison for the condemned, sometimes an additional one for the gladiators, and there's at least one sort of attestation of an amphitheater that has both. And then around the arena, there are also these small boxes for holding animals that are yet also called carceres, right? So they're all called and thought of in some sort of general sense, at least some linguistic sense, as similar. Similarly, also like the starting gates at the beginning of a circus where the horses are let out are also called prisons, right? Or right. So this this commonality is not lost on native Latin speakers. I have not looked into the sort of the archaeology of restraint of animals, although my suspicion is that what I will find is exactly what you point to, which is that the operative distinctions in forms of restraint often relate to the ideals behind the restraint rather than the sort of the material sort of factor. So it is almost impossible archaeologically to distinguish between somebody who is incarcerated and somebody who is enslaved, because the mechanics of their binding is often identical, even though the ideals behind them or sort of the rationale are different. My suspicion is that that could be extended to sort of the non-human animal world as well, but it's worth looking into further. Thank you.
And Leon?
Thank you. Thank you for all the wonderful presentations. Could I ask two questions? Or
Sure.
I have, okay.
Sure.
So I have one question for Professor Ari Bryan. So the first section, so you talk about confiscation. Actually, that's, Chinese legal punishment have a lot confiscations. So one is, do they, have the legal statutes prescribe how in what scenario you will confess family property after one commit crimes? Also is when they confiscate the family property, does it include children and the wife, right? In Chinese, actually the wife have a lot of independent power. They have economic power. They could become the owners of the property. But when their husband commit crimes, the wife will be confiscated as slave. Yeah, thank you.
Sure. So the answer to the first question, how much of this is statutory, is, well, quite a lot of it. That there's all sorts of laws that get passed that especially with these things like the confiscations that come from creating a trust that allows you to dodge rules of inheritance. This is as far as I can tell statutory, but that's not it, right? And so there's a statutory path by which people do this, and you see these in various recommendations, like this document from Egypt that I was talking about. But then there's also a tendency to say, okay, well, you've somehow failed in one of your obligations, and so we're simply taking your property. So it's not exclusively statutory, which is I think an important thing. It's a deeper reflex of a system that imagines ownership as a patriarchal ownership as the end result of fulfilling a certain set of political and ethical and financial obligations. So it's an instinct that is deep in this system. Now, what about families? Well, we have to get into some technicalities of Roman law here, but no, other members of the family are not formally being punished, with one very important exception, which is that property owners or owners of land are also vast owners of slaves. And so what do you do with the slaves in some of these scenarios? Well, obviously they seem to escheat to the fisc. Is the first answer. But there are also properties where they're not supposed to do that, right? Where let's say they're highly talented agricultural managers who are attached to a particular piece of land, and the jurist, I think it's Gaius, complains that you're really actually not supposed to sell these people off, right? They're supposed to convey essentially along with the land. The problem is, if they convey along with the land, they're probably going to blab about something that has happened in this process that is not on the up and up. And so you find that these managers of fiscal properties are selling off the slaves as fast as they can because they don't want these guys sitting around talking. And so what to do with the living property, slaves and chattels, that attaches to the landed property? There are hints that this is a much trickier problem. Now, the children are sort of a different story. The children essentially just get robbed in this. And in some circumstances, some of the property is returned to children in the name of the state, right? That is, the state becomes the giver of the inheritance to the children rather than the father. And that also speaks to interesting questions about how family and genealogy is constructed in this particular branch of criminal law. But I won't go on at great length because I get very excited about this.
Thank you.
And you had a second question?
Well, second question is for Professor Walpole and Professor Nanning. How about the people who wrongly accused others? What happened to them, right? So they, we got the first story that you got a lot of wrong accusations. In Chinese case, so you got legal statutes, have severe punishment if you have the wrong accusation. And also you have, cases, people have wrong accusation got punished. But the sources still show people constantly have wrong accusations. So it's very interesting, what's really going on, right? You are going to be punished, but you are still doing that.
Yeah, so the initial thing that comes to mind is, if you bring a public case and you don't get 1/5 of the jurors' votes, then there's a fine. And possibly if it happens more than 3 times, you might even lose your ability to bring a case. It's a little bit unclear, but at any rate, but that's only if you really lose the case. there isn't a sense that you get, as I understand it, in some of later Roman law and other societies where, just losing the case in itself, you automatically need to ask about there's like a second question that has to immediately be raised about, is this frivolous or something like that? As long as you, get at least a fifth of the jurors' votes, then it's okay. And then, as Professor Wolpert's talk suggested, there's a whole, rhetoric and literature about so-called sycophants who are frivolous or malicious prosecutors and so forth. There was a real fear that the Athenians had about this.
And there is also the paragraphe, which could block a wrongful suit, but that's only if the charge was incorrectly worded. And yeah, as Professor Lonnie mentioned too, it's only in the public suits where you could be fined or punished for it. There's also like legal decrees and so forth. So there are certain options, but with private suits, there's more flexibility because I guess I would interpret it to mean that they want to make sure people can proceed with legal actions if they felt like they were wrong. So the greater concern was mainly for public offenses, that people aren't misusing that venue to attack others.
Thank you.
One other thing to mention is that ironically, often what you would do is there was no way to get back at your prosecutor per se, but you could sue all or prosecute all of the other side's witnesses, all of the prosecutor's witnesses for false witness. So in some ways, it was really more the witnesses who were accountable for a bad prosecution rather than the prosecutor.
Thank you.
Alrighty, we've gone slightly over time. I want to thank everyone for their generosity with their time today, for the committing to the full 2 hours of this. I think this was a great day. I think the papers sound fascinating. I hope it put before the audience of this something of both the richness of the field and its theoretical diversity, but also some of the ways and methods that the scholars in the field of ancient law are using to grapple with the kind of very different but always imperfect evidentiary regimes that they're handling. I also hope that that the final publication will bear the fruits of some of the commonalities and theme that have emerged across the papers here today. And with that, I would like to thank the audience and also thank Marcus for hosting this.